Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about ATF's rule on frames and receivers again. On Monday evening, there was word that the United States Supreme Court had yet again stepped in on a case on an emergency basis, and the news apparently was not that good. I've had an opportunity to go through the ruling. I've had an opportunity to go back and look at the procedural history of the case, and I want you to understand that it's probably not as big of a deal as some made it out to be, and I don't think we should be reading too much into it. So I'll tell you why I think all that. We'll connect some dots for you and we'll get you educated. So today, let's spend a few minutes and let's talk about what really just happened at the Supreme Court on the frame and receiver rule. Okay, so the case we're talking about, and we've talked about it many times before, is the case of Vanderstock v. Garland. This is a challenge to ATF Rule 2021R-05F, better known as the rule on frames and receivers, better known as ATF suddenly deciding that in addition to firearms that they can regulate, they get to just regulate chunks of aluminum as well. Now, this suit was filed in the United States District Court for the Northern District of Texas. There were many named plaintiffs in it. However, the two main plaintiffs that we're going to focus on today is a company called 80% Arms, another company called Defense Distributed. You can imagine what they do for a living. You can imagine what this rule does to their income. Now, let me explain to you what the Supreme Court really did here, okay? Because I think if you don't scratch under the surface, you're going to think that they just tubed everything and that this rule is going to survive and you all are going to be subjected to it for the rest of your lives. That is not necessarily the case at all. Let me explain what happened. We'll use this little diagram to try to break it down for you. Okay, so the case gets filed in the United States District Court, Northern District of Texas. It's before Judge O'Connor. Plaintiffs argue that this rule far exceeds the Administrative Procedure Act and any statutory scope of authority that ATF may have had, which it does, and the court issues an order basically saying this rule is unconstitutional in its formation and the injunction is one of vacatur. Huge win for the plaintiffs. Of course, the United States government immediately freaks out and appeals to the Fifth Circuit. Now, if you're the federal government, the Fifth Circuit is probably not the best circuit to be appealing gun cases. It's kind of the anti-Ninth Circuit. And so what happens in the Fifth Circuit is they too decide to keep the injunction in place, which basically keeps the ATF from enforcing this rule against just about anybody. Now, the United States government, still crapping its pants, then moves to the United States Supreme Court for an emergency order to stay that. The court steps in, the United States Supreme Court steps in and issues a stay of the injunction on that. So which means the rule now goes back into effect. It then is kicked all the way back down to the district court in the Northern District of Texas where Judge O'Connor is. He then issues a new injunction. The new injunction is more narrowly tailored than his first injunction, but it is still an injunction nonetheless. The United States then appeals again to the Fifth Circuit, and this time the Fifth Circuit partially agrees with the United States government and says, yeah, Judge O'Connor probably did overstep it, so they strike down some of that injunction. What's remaining, though, is that 80% Arms and Defense Distributed are still enjoined from enforcement of this rule. The United States government then moves for, again, an emergency hearing on a stay, and that is granted by the United States Supreme Court on Monday, the 16th of October. So what has really happened is a rule that was vacated and then enjoined and then re-implemented against just about all of you has been re-implemented on a handful of people that it did not apply to. So the effect of this Supreme Court ruling on you today is de minimis at best. Now, what's also curious about this, however, is that on this one, there has been no, at least published, dissenting opinion. So it would appear that all 9 justices were actually in favor of this. Now, let us not forget that the last time the United States went crying to the Supreme Court on this exact case, this exact issue, 4 justices had actually voted against issuing the stay. That was Justice Thomas, Alito, Kavanaugh, and Gorsuch. Interestingly, Chief Justice Roberts, as well as Justice Coney Barrett, had joined the liberal minority to actually give the majority opinion on that particular case. In this case, at least at the time being, it looks as though this was a 9-0 decision, which doesn't make a lot of sense, recognizing that at least 4 justices were against even staying this to begin with. Now, I know it is easy, especially in the year 2023, to see nothing but doom and gloom from a ruling like this. But if you go back and you track a lot of other major litigation that's gone through the Supreme Court, it is rare that the Supreme Court will stop a law from existing while it's pending the appeal. More frequently, the law will remain in effect and then be struck down at a later date. So there's not a whole lot you can read into this necessarily as, oh my God, we're doomed. The United States Supreme Court is ultimately going to uphold this rule. I think the reasoning of the lower court, the reasoning of the Fifth Circuit is incredibly sound, especially as it relates to all of the stuff on the Administrative Procedure Act. I think those are very, very solid arguments and should carry the day. Ultimately, what the court said about this stay is, listen, after the Fifth Circuit issues its final ruling on the legitimacy of this rule, if certiorari by the United States Supreme Court is not granted, that ends the stay and that ends the existence of this rule. However, if the Fifth Circuit does rule to strike down this ATF rule and the United States then accepts certiorari, the stay will end upon publication of the Supreme Court's opinion. Obviously, we have a long way to go. This is just one of the many, many battles in a very, very large war that is currently being fought on multiple fronts. The case, once again, is Vanderstock v. Garland. We'll link it all up down below, including the Supreme Court's order, so you can see what the real impact of this order really is to you. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down in the description box also. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.